All right. Well, hey, welcome back, everybody. Welcome back. I know many of us are back. Some of us are not. But those of us who are here, welcome. Welcome. Appreciate you coming back. And I always like to do my post-mortem after a class. And I did my own kind of post-mortem of last week's class. And I hope I'm not misinterpreting how last week's class went, but I think it went pretty well. Yeah, okay. I liked your performance. I really did on our in-class exercise. I really saw from you great evidence that you're grasping what it takes to satisfy that standard of Michigan versus Long, so that the Supreme Court of the United States either can, from a procedural standpoint, take jurisdiction on a writ of certiorari, or is denied jurisdiction on the writ of certiorari. And I think that's an important concept to grasp. And certainly it's part of the graded essay that we've got coming up. Now, more information to come on that graded essay, what I've asked the faculty assistants to hunt down and do for me. And I hope they will. They've always been so helpful to me in the past, is to find a way so that the essays can be collected from you, these graded essays that are required, can be collected from you in such a way that I don't see you handed in. So I'm asking one of the faculty assistants to be the collector, so to speak. I'm hoping that it can be set up so you can email it, because nobody should have to schlep over here just to hand in an essay. And then you can do it in any format that you like. You want to handwrite it, that's great. You want to type it, that's great. You want to use Braille, I will find someone to translate the Braille. Likewise, if you don't speak English, I only speak English, and I apologize for that, but I'll find someone to translate from whatever language you write it in. I want to be as flexible as possible on that. And I want blind, anonymous grading. I don't want to know who wrote what it is that I'm reading and grading. So I'm going to ask the faculty assistant who collects the essays to redact, to take off your name and to replace it with some randomly assigned and meaningless to me anonymous number, so that I can grade it without knowing who wrote it. I can assign the grade based on the anonymous numbers. I can then hand the grades next to the anonymous numbers list back to the faculty assistant, and then the faculty assistant can translate and tell me who it is got what grade. And that's really important to me, because this should be a no bias zone. There shouldn't be any bias by the people who are grading your law school work, me included. So I reached out to them for that help. I'm sure I'll get it. And that's what we'll do. So more to come on that information. So I remember when I showed up last week, I was turning on the computer, the monitor being blank, kind of looks like a mirror, and I noticed I myself was looking pretty haggard. Hopefully I'm looking less haggard today, but I'm not feeling any less haggard today. Maybe you've been in this situation too. Maybe you've been in the situation that I've been asking myself for a week and a half now. Am I good enough? Anybody ever ask themselves that question? Am I good enough? I'm certainly asking myself that question, because the pressure is on my innocent client. Of course, all my clients are innocent. My innocent client, he truly is innocent. As you know, as you remember, I defend my fellow lawyers who have ethics complaints, bar grievances, ethics investigations, charges by the Florida bar. I fight the Florida bar. And the Florida bar is mistaken. My client did nothing wrong. And about a year, it was May of 2018, so a year and 5 months ago, this 2-week trial, thousands of pages of evidence, witnesses, the likes of whom, the credentials of whom I'd never encountered before, IRS agents in the criminal investigation division, housing and urban development, criminal investigation. Did you know HUD had a criminal investigation division? I didn't know that. All testifying on the stand about how guilty my client is when he is not. And thankfully, after all of that, I managed to convince the referee. That's what the Supreme Court of Florida calls the judge. They delegate the trial to. The referee found my client not guilty on all charges. So that was wonderful, except the Supreme Court of Florida found a technical flaw, reversed and remanded for reentry of a new order. I saw that and I kind of laughed, because I had the judge convinced the judge is only going to fix the technicality and re-sign the order. The referee will do this for me, I know. And that's when I find out the referee has retired. Will no longer be presiding. So I got a brand new judge, one I've never appeared in front of before. Bar counsel, who I've gotten to know well by beating her, likewise is no longer working for the Florida bar. She's in private practice. I got a new bar counsel I've never met. Is she a genius? Is she a moron? She's probably a genius. I got to figure out a way to win the trial again. And I talked to my buddy Fred Trable. He does criminal law. I don't. He says to me, in criminal law, the most stressful thing is to represent a truly innocent person because the pressure's on. And likewise, in my bar grievance defense, I got an innocent client. The pressure's on, but the pressure is multiplied because this clearly is a winnable trial because I won it once. I won it once, so I got to win it again, right? If I don't win it again and I won it once, then the loss must be my fault, right? I don't want to be the blame.
Just means you last 2 out of 3. It's fine.
Oh, I don't know if I'll get another duel. Maybe I'll get another. Let's not lose this retrial, so I don't need another duel. So maybe you've asked yourself the question I've been asking myself for a week and a half. Am I good enough? I'm 48 years old. We're practicing for 23 years, and I still ask myself that question. So maybe you ask yourself that question from time to time, too. Spoke to my former law clerk. She is anticipating that within the next week, her results of taking the Florida bar exam will be back. I bet she's asking herself the same question I've been asking myself. Am I good enough? And as you know, midterm weeks is rapidly approaching for all of you, is it not? And as you look at the material, whether in this class or any other, maybe you're tempted to ask yourself, am I good enough? And maybe this is just part of humanity. Maybe this is just part of being human. Can't help but ask yourself, am I good enough? So the question then becomes, how do you deal with that situation? And when you're licensed to practice law, which I know you will be, how do you deal with that situation? How do you answer that question? Am I good enough? So everyone's got to find a way to deal with that doubt. I hope you've found a way to deal with that doubt. And if you haven't found a way to deal with that doubt, then I would encourage you to find a church, synagogue, mosque, place of worship that you feel is most appropriate for you, and see if it can be that source of strength for you. As for me, you know my faith. I'm Catholic. I'm a man of many flaws, not the least of which is that I wear my faith upon my sleeve, and I love talking about the Catholic faith because I love the Catholic Church. I love what it does for the world. I love what it does for me, and part of what it does for me is that comfort when I ask myself that question, am I good enough? Am I good enough? Because that salvation that Christ offers to me through his one holy Catholic and apostolic church, it helps me to answer that question. And I hope whatever church, synagogue, mosque, place of worship that you've chosen, I hope it brings you that same strength too. Because as a practicing lawyer, there'll be those times where you're feeling that doubt, and you're going to need that source of strength that Jesus Christ can be for you, that his church, the Catholic Church, can be for you. And I'd like to think, we look at Scripture and we try to see ourselves in Scripture. Sometimes it's harder than others. I never have any trouble seeing myself in the story of the prodigal son, because that prodigal son, you know the story, right? He's pretty darn worthless, which is pretty close to what I am. Hey, you remember the story. I can just paraphrase it because you know all the details. The guy tells his father, I want my inheritance right now. I mean, as if he's dead already, right? And what does he do? He spends it, he wastes it all, and he finds himself not living high in the hog, but living lower than the hogs are living. He literally saying to himself, back at my father's mansion, the servants who feed the pigs have a better life than I do. So the man has a plan, the prodigal son, does he not? He comes up with a beautiful plan. First, he comes up with a beautiful speech, much like a lawyer would prepare a motion or a brief or prepare their oral argument. He's got all the words in a row, he's going to say these words to his father. He's got some prepared words for his father. If you will, he's got a prayer. He's got a prayer to make to his father. And he sets off up that great hill to his father's mansion. And this part of the story I love. Please don't miss this part of the story. It says, while he was still a way off, the prodigal son hadn't gotten there yet. While he was still a way off, his father came out to meet him. Did you notice that part of the story? And then notice also, Will, he starts to give the speech, the beautiful prepared speech, the exact words of the prayer, if you will. And his father cuts him off. He didn't have to finish. His father already is ordering, put a ring on his finger, put a cloak On his back slay the fatted calf. What once was lost now is found. My son has returned. You know? And the reason I bring it up is because that's what the Catholic Church does for me. And I hope whatever church, mosque, synagogue, or place of worship you go to does it for you. If not, come see us at the Catholic Church, because that's what it does for me. Sometimes I don't get the prayers right. Sometimes the prepared speech and the words I've got to say to my Father don't come out quite right. Sometimes I don't even bother to say the prayer. I don't pray enough. Maybe that's true for you too. But I know that while I'm still a ways off, while I'm still as worthless as the prodigal son, I wish I could improve my worth to be as worthless as the prodigal son. While I'm still that worthless, while I'm still a ways off, he's coming to see me. He's coming my way. So with that said, I always like to start each class with prayer. And thank you for indulging me on that. A beautiful school here allowing me to do that. So if you care to join in, pray with me now. I'm praying for each one of us. I'm praying for you. Those times when you ask yourself, am I good enough? I want you to remember that the answer can be yes. That the answer can be yes. When can it be yes? Well, on the one hand, there's your will. There's what you want to do. There's what you want to achieve. And on the other hand, there's God's will. There's the Lord's will. There's what he wants to achieve. It's when you take those wills and you put them together. It's when you surrender. It's when you say, Lord, not my will, but yours be done. That's when you commit yourself and your works to the Lord. That's when your plans will be established. So that's my prayer for you. My prayer is that your will is his will and that your works will be established. In the name of the Father, the Son, and the Holy Spirit. Amen. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done, on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. Lead us not into temptation, but deliver us from evil. Hail Mary, full of grace, the Lord is with thee. Blessed art thou among women. Blessed is the fruit of thy womb, Jesus. Holy Mary, Mother of God, pray for us sinners, now and at the hour of our death. Amen. Remember, O most gracious Virgin Mary, that never was it known that anyone who fled to your protection, implored your help, or sought your intercession was left unaided. Inspired by that confidence, I fly unto thee, O Virgin of Virgins, my mother. To thee do I come, before thee I stand, sinful and sorrowful. O Mother of the Word incarnate, despise not my petitions, but in your mercy hear and answer them. Amen. In the Father, Son, Holy Spirit. Amen. All right. So where did we leave off? Our next topic had to do with that loaded question that I left you with last week. And you remember our friend that was running around the room. Yes, some of us tripped over our friend. I know I did. Others might have slipped in the remains of our friend. Our friend needs some potty training, perhaps. Who is our friend? Our friend is the living Constitution. Yeah, the living Constitution. Because obviously a piece of paper could be alive, right? We've all been indoctrinated. Educated. Gosh, slip of the tongue there. We've all been educated to know the fact, for those of you who are watching, those are my air quotes, the fact that the Constitution is a living document. How can a piece of paper be alive? How can it have things sticking out of it that we can't see, these emanations? How can an invisible thing like an emanation cast a shadow, a penumbra? All I know is that this living document, it has rights that aren't there, formed by the emanations, formed by penumbras. So the question I left for you, this loaded question is, if that is true for a U.S. Constitution, is that also true for subnational constitutions? Is that also true for state constitutions? Is that also true for the Florida Constitution? I left that question for you to think about, and I left it unanswered. But you do understand the relevance of the question, right? You do understand what those who indoctrinate, educate us mean when they say a living constitution, right? And you probably heard it if you've gone to school here in the United States. You probably heard it since a very young age. My son was 10 years old, and last year, when he's 9 years old, my wife and I, he's home and he's already heard. He's been indoctrinated, educated to the fact that it's a living constitution. So my wife played along with me. I said, Patrick, do you understand what that means? Understand what it means to be it's a living constitution? And he could regurgitate the words, but I don't know they fully understood. So I said, all right, Patrick, you and Mom here, why don't you come to an agreement? My wife Bernadette, she's playing along. Why don't you take this piece of paper, all right? And you love chocolate ice cream, Patrick. How about you have chocolate ice cream for dinner? A bowl of chocolate ice cream for dinner. Already he's suspicious. But he and Bernadette, I take out a piece of paper for them, and Bernadette writes the words and signs. He too signs the words and says very clearly on that piece of paper, my son, Patrick James McGinley, will eat chocolate ice cream for dinner. With that piece of paper signed, I went into the kitchen. I got a big bowl, and I came out with a big bowl of steaming broccoli for Patrick to eat. He's upset. Mom and I wrote it down. We signed it on a piece of paper. I'm supposed to eat chocolate ice cream. I said, Patrick, that piece of paper, it's a living document. Yes, it's true that you meant chocolate, and that's why you signed it. Mom meant chocolate. That's why she wrote it. I see the paper. It says chocolate, but Patrick, it's a living document that I have to interpret based on today's needs and understanding. You're a growing man, Patrick. You need broccoli, not chocolate. That's what a living document is. It's something the authors never intended, that the signatories never intended, but that some enforcing party, in this analogy me with my big bowl, decides it means anyway. So can that be true for our state constitution? That's what we're going to explore today. I call the chapter Canons of Construction and Other Potential Sources of Judicial Restraint, because it's only if there is a source of judicial restraint on the state level that the state constitution will not be a living document. But join me in the reading, would you? We're on chapter 2. You got the printed version. We're on page 43. How must Florida courts interpret Florida's constitution? And I take a look there at some surveys. And I ask the question on that page, does a constitution mean whatever the court interpreting it prefers it to mean? And if you ask the layman, the non-lawyer, the woman and man on the street who hasn't gone to law school and isn't a licensed lawyer, if surveys are correct, Americans are divided in their beliefs about how courts go about and should go about interpreting a constitution. I'm citing there to February 2014 survey by the Pew Research Center. I'm not familiar with them, but I cited it anyway. It says here, about half of the public, 49%, says that the decisions of the U.S. Supreme Court should be based on its understanding of what the Constitution means in current times. Sure, a few minutes ago it meant a bowl of chocolate ice cream. But here in current times, I know it means a big bowl of steaming hot broccoli, right? So half the public believes that's how it should be. Roughly as many in this Pew Research, 46%, say decisions should be based on what the Constitution meant as it was originally written. In other words, my bowl should be full of chocolate ice cream. But that's not good for Patrick, right? I know what's good for Patrick. And in my role as Supreme Court Justice of that bowl, right, that paternalistic role, I can overrule the democracy of Patrick and his mom, Bernadette, because I know what's best for Patrick. So the living constitution concept really comes from that high and mighty, that lofty belief that somebody, namely the justices, know better than you and I, the democratic process. The voters, the people. And you may have an opinion as to whether that's good. You may have an opinion as to whether that's bad. You can probably tell at this point what my opinion is. But I'm not here to indoctrinate. I'm here to educate. You reach your own conclusions. Clearly, I'm arguing for one conclusion, not the other, but you reach your own conclusion on that. The public certainly has reached their own conclusion. If you notice on the bottom of page 43, I turn to another survey. This one's by C-SPAN and Ben Schoen-Berlin. Again, not familiar with Ben Schoen-Berlin. I am familiar with C-SPAN. That's that channel you've got to turn past to get to the one you want to watch, right? So according to their survey of March 2017, 62% of voters say that the U.S. Supreme Court justices are split on political grounds, just like Congress. In the same survey, barely more than 1 out of 3 voters, or 38%, say that the U.S. Supreme Court acts in a serious and constitutionally sound manner. Quoting from the survey, Robert Greene, principal of PSB, which has conducted 11 national public opinion surveys, I guess I'm singing their praises at this point, including 6 studies commissioned by C-SPAN. He opines, whoever he is, that the public's perception of the U.S. Supreme Court as a partisan political entity did not form overnight, and he lays the blame on both Republicans and Democrats. So he's got bipartisan blame for a partisan court. But at least in the public's perception, SCOTUS, Supreme Court of the United States, is as partisan and political as Congress. Is that true? Is that not true? Again, I'm here to educate, not indoctrinate. You reach your own conclusions. But if it is true, then the nomination of a new person to sit on a seat of the Supreme Court of the United States would be a very controversial event, would it not? It would be. If it were true. And I don't know, have there been any controversial nominees? Have there been any nominees who in reality were not controversial at all, but yet somehow, some way, somebody drummed up some controversy about that individual? Unwarranted controversy, unproven controversy, controversy that wouldn't survive summary judgment in a federal court, but somehow became the topic of a federal congressional hearing? Again, not here to indoctrinate, just to educate, reach your own conclusions on these questions. But I'd be remiss if I didn't point out that obviously I've reached my conclusion out of it. But you can reach yours. Let's take a look at this question. Assume that the proper use of Michigan versus Long, and well done, again, well done with that in-class exercise last week. Writing a potential argument that you would use in a brief on jurisdiction to the U.S. Supreme Court, arguing whether or not there should be granting a petition for writ of certiorari. Well done on that. Well done on applying Michigan versus Long. Assume that the proper use of Michigan versus Long empowers the state's high court to issue rulings over which the U.S. Supreme Court would then lack jurisdiction to review. Without the safeguard of U.S. Supreme Court review, what restrains the state's high court? Remember, they may not be infallible, but they're in a way infallible because they're final, right? To whom do I appeal? Guess I could amend the Constitution, but otherwise, to whom do I appeal? One possible answer to consider is that the ethics of the judges and this principle of judicial restraint could prevent abuse and safeguard against possible improper interpretation of a state's constitution. But are these safeguards sufficient? Do we have sufficient safeguards in place? Let's look first at SCOTUS. And that's why I pointed out to you, provided you an excerpt from the summer 2013 article in the Georgetown Journal of Legal Ethics, written by Amanda Frost, Judicial Ethics in Supreme Court Exceptionalism. And in my excerpt of that article, I share with you her well-done research about what exactly restrains, what confines, what forces judicial restraint upon SCOTUS, upon the justices of the Supreme Court of the United States. And look at that second full paragraph that I've got in the excerpt there. There are 3, according to her research, different statutes governing recusal of federal judges, but of these 3 statutes, only one out of 3 applies to the Supreme Court of the United States. That's Title 28, Section 455. That statute requires, quote from it, any justice, judge, or magistrate judge of the United States, so that'll apply to SCOTUS, requires him to what? Disqualify himself, sorry about the gender there, I didn't write it, disqualify himself. How? Who rules upon a motion to disqualify a justice of the Supreme Court of the United States? Is it the lower court? Absolutely not. It's SCOTUS itself? Almost. It's the justice you want removed. And that justice alone, who decides whether you're right or you're wrong as to whether or not that justice is recused. Oh, but you'll get a written opinion, right? Well, you'll get a written answer, but it won't express the why or wherefore. It won't be an opinion, so to speak, because the justice is not under any obligation to explain to you whether the justice decided that the justice should be removed. Look at the next possible source of restraint. This was the Federal Ethics and Government Act of 1978. That applied to SCOTUS. Great. We need ethics in government. We need ethics on SCOTUS. Don't you agree? We all need ethics. Who's against ethics? Raise your hand if you're against ethics. No hands are up.
Nice try.
Almost, huh? Ethics in Government Act of 1978 applies to SCOTUS, but applies to make them do what? I read it to you here. File annual reports in which they publicly disclose aspects of their finances, such as their outside income, the employment of their spouses, independent children, investments, reimbursements for travel-related costs, gifts, household liabilities, yada, yada. Okay, so they've got to disclose them, right? And then, well, what if you don't like the disclosure? I guess you can lament. How about that, huh? Probably the same way it works in Chairman Kim's jurisdiction over in North Korea, right? If you don't like what Chairman Kim did, you could lament. Probably don't want to do that out loud over here at Chairman Kim's jurisdiction. But over here in the good old US of A, you could lament out loud about a Supreme Court justice, right? Not the same as getting a recusal, but you could lament. Next paragraph, the Ethics Reform Act of 1989. That applies to SCOTUS. Applies to make them do what? Judges and justices are prohibited from most outside employment with the exception of teaching. Oh, great. My job's the only one that's not protected here, huh? So with the exception of teaching. Okay, so at least we know there's no moonlighting, there's no concurrent employment, there's no job on the side. All right? Look at the next example. The Code of Conduct for United States Judges. Oh, this is important. Congress has passed the Code of Conduct for United States Judges. Does that apply to SCOTUS? It applies to United States District Courts. It applies to the U.S. Courts of Appeal. It applies to the magistrate judges. But it doesn't apply to the 9 justices of the United States Supreme Court. It doesn't apply to SCOTUS. It doesn't apply to them. And here's probably, for those of you who are hoping to find a source of judicial restraint here in Amanda Frost's Georgetown Law Review article exhaustive list of potential federal statutes imposing judicial restraint. Perhaps this last paragraph would be the most foreboding for you. The constitutionality of the ethics laws described above, says the author, has never been addressed by the U.S. Supreme Court. Although a few critics, including some of the U.S. Supreme Court justices themselves, have raised constitutional concerns about applying ethics laws to the Supreme Court. So most of these laws didn't even apply. The ones that do apply are untested as to their constitutionality. And ultimately, who's going to decide that constitutionality, if and when it's ever been tested? That would be the SCOTUS justices themselves. And as Amanda Frost is telling us in her Georgetown Law Review article, some of them have already spoken out and given their opinion on that. So what do you think? Where do you stand? What's your opinion? Supreme Court exceptionalism. Should they be exceptional? What are the pros? What are the cons? Who wants to join this conversation? I'll warn you, I've got my little laptop up here and I'm recording it. Yeah. So, all right. Who wants to speak up? Yes.
I think that the Supreme Court exceptionalism in regards, not just the Supreme Court, but in regard to government in general, all of these executive and judicial exceptions to the law is like executive privilege. He doesn't, the president do what he wants. The judicial ethics for the Supreme Court, they decide what they do. I think that all of that's terrible. And that if you're going to be telling me what to do, if you're going to be standing over me, telling me what is right and what is wrong in my life, then you better be squeaky goddamn clean and have nothing on you. But that's not the way the world works.
Yeah. And you end with that pessimistic comment there. That's not the way the world works. And nothing you said was incorrect. Nothing you said was incorrect, because that is the way the world works. But if there's one takeaway, one message, one point I'd like you to learn before the semester is over, is that you get to decide how the world works. Am I being too melodramatic about that? Am I being too optimistic? I dare say I am not. I'm not. I love lawyers. I really believe that lawyers are in a better position to change the world than most professions, most Americans, most people. So if I point out to you the way the world is and you don't like it, change it. Change it. Where's that change going to come from? Where do I look for that change? How about looking in the mirror? But back to the point at hand. What's the argument for Supreme Court exceptionalism? Well, we talked in the preface to this discussion about the politics of it all. Perhaps Supreme Court exceptionalism could, perhaps even does, allow the Supreme Court of the United States to rise above politics. Imagine, if you will, you could recuse a justice of the Supreme Court of the United States by having that motion for recusal decided by another tribunal. Imagine, if you will, that you've got a hot topic, a political topic, which allegedly, if you lean left, you would vote this way, and allegedly, if you lean right, you would vote that way. Wouldn't a good litigant who has a good faith argument for recusal almost feel compelled to try to recuse the judges of the Supreme Court that the litigant concludes would be leaning against their party? Wouldn't it be a part of every Supreme Court litigation to have these types of motions? And is that what we want Supreme Court decisions to be about? Do we want it to be about choosing the judge, the litigants winning the correct judge? Or do we want it to be about choosing the law, the litigants arriving at the right ruling of law? I got a hand up, yeah.
So the issue with taking that approach is the fact is the flaw is in how the Supreme Court justices are selected at this point.
So you don't like the selection process?
So like, I mean, if you're going to ask to be able to recuse a Supreme Court justice, the fact is, at this point, there's always going to be a reason for it. Now, in certain cases, Supreme Court justices, no matter which way they lean, the right argument can get a Supreme Court justice to flip sides, so to speak. So like, it still does.
And we've seen that. You're right about that. I'm sorry to interrupt you. I'll let you have the floor back in just a second, but I'll just like your comment, because we've seen that. We've seen allegedly Justice so-and-so is, leaning right or leaning left, and then surprise, rules with the other side, if you will. So I'm sorry to interrupt you. Go ahead. I wanted to highlight that point of yours.
It is still possible for them to flip. Now, obviously, if the process becomes too hardened on either side, they get to the point where no justice flips, regardless of what the law is.
And we've seen that too.
So I just think when you're taking this approach, the process, the justices aren't the issue; it's how the justices are selected. So like, you are always going to have an issue with refusal if the process stays the same.
Yeah.
You couldn't get around it. You would be asking them to reject the judge for the reason.
And I think you're now mirroring my point. Yeah, that would be a natural part of Supreme Court litigation, would it not?
Yeah.
Trying to stack the bench, if you will, your way. And exceptionalism at least has that advantage. It avoids that part of litigation. Maybe it has other advantages. Do you see other advantages? Something to think about. Here's some more questions to think about. Let's look at begin the bottom, page 46, going to the top of page 47. Note 1. Notes and questions to consider. Number 1, what benefits, if any, accrue from the fact that the Code of Conduct for United States judges does not apply to the justices of the United States Supreme Court? Assuming there are benefits, why would the Florida Supreme Court subject its justices to the Florida Code of Judicial Conduct? Did you notice that? In my material that I wrote for you, after Amanda Frost's excerpt of her Georgetown Law Review article, I discussed the state of Florida's equivalent of the U.S. Code of Judicial Conduct for United States judges. here in Florida, our code of conduct applies to all of the judges, whether they are state trial court, state appellate court, such as our 5 district courts of appeal, even if they're on the Supreme Court of the state of Florida, the same rules apply to the Supreme Court of Florida judges that apply to all of the Article 5 judges. In the U.S. Constitution, Article 3 establishes the judiciary. In the Constitution of the state of Florida, Article 5 establishes the state judiciary. All judges who exist because of Article 5 are governed by the same code of conduct, even the Supreme Court of the state of Florida judges. So if Supreme Court exceptionalism, Supreme Court of the United States, SCOTUS exceptionalism is so great, why did the state of Florida make the opposite decision? And of course, this goes back to that essential tenet of Catholic social justice teaching. This goes back to subsidiarity. This goes back to the fact that each state, in its constitution and in its case law precedent that has an adequate and independent state law basis as defined by Michigan versus Long, each state gets to decide these kinds of issues for itself, for its own state judiciary. And here in the state of Florida, Florida has decided for less exceptionalism for our state's highest court than the federal system has chosen for SCOTUS, for the federal highest court. So we see a difference there. Let's look at note 2. Note 2, on middle of page 47. Bless you. Generally speaking, when a judge or justice of a court other than the United States Supreme Court enters an order that makes a harmful legal error, and the aggrieved party preserved that error below and files a timely and sufficient notice of appeal, then the appellate court could be convinced to reverse or quash the order containing the error. That's the premise behind appellate practice, right? But here's the question. Would the fact that the lower court judge or judges signed such a legally erroneous order subject the judge or judges to discipline under the Florida Code of Judicial Conduct? Why or why not? And the answer is it would not. In our written materials that I wrote for you, I take a review of the Code of Judicial Conduct that applies here to our Florida Article 5 judges, and I look for something. Did you see what I looked for? I looked for, was it a punishable offense? Was it reprimand? Was it something a judge would be unethical to do? If a judge had a political leaning. Remember our introduction. The general public, the non-lawyers, the laywoman, the layman, they perceive SCOTUS, Supreme Court of the United States, as partisan as Congress. What if a state's high court, what if the Supreme Court of the state of Florida were perceived to be, or what if it was partisan? Could a partisan bias be something that would subject a state of Florida Supreme Court justice to punishment under the code of ethics that apply here in Florida? My conclusion was no. Read through the canons yourself, read through my written materials, see if you come to a different conclusion. I suspect that you won't. I believe I came to the correct conclusion. But again, I'm here to educate, not to indoctrinate. Note 3. I love this one. I love it so much that I've put it on the exam, the final exam, multiple times. Who knows? I might put it on your final exam. Who knows? No promises. Note 3. What would you call a decision of the Supreme Court of the state of Florida that interprets the plain language of the Constitution of the state of Florida, does so by citing only to the text of Florida's Constitution without any citation to any other authority, and contains a plain statement that the Supreme Court of the United States agrees is an adequate and independent basis for that decision under Florida state law? I'm hoping somebody's got the answer here. What would you call that? What would you call it? Yes. Well,
The textualist?
That would be a textualist approach to reaching the answer. Can't disagree with you there. But my point I'm trying to make is what you would call that is the new correct interpretation of Florida's Constitution. My point goes back to Michigan versus Long. Look at the facts that I've outlined in that statement. What I've described there is an adequate and independent state law basis. What I've described there is one of those rare and few instances where it's not a matter that the Supreme Court of the United States shouldn't take jurisdiction. It is, in fact, a matter that the United States Supreme Court couldn't take jurisdiction. They lack jurisdiction over such an order. So, if the Supreme Court of the United States lacks jurisdiction over such an order, and this is the ruling of the Supreme Court of the state of Florida, our highest court, then what is that? That's unappealable. That's binding. That's the final say. That's the new correct interpretation of Florida's Constitution. And at least in one instance, as we finish out our semester, a case that involves Pan Am, you're going to see an instance where it looks to me, again, here to educate, not indoctrinate, you reach your own conclusion, looks to me that the state of Florida did that. It's a 1980s decision we'll go over. Looks to me that they misinterpreted the text of the Supreme Court of the Constitution of the state of Florida, but did so with an adequate and independent basis. So what do you call such a misinterpretation of the plain language of Florida's Constitution that has an adequate and independent state law basis? You call it the new correct interpretation of Florida's Constitution. So what we have here, again, is that potential for a lack of judicial restraint, either deliberate or inadvertent, in such a way that we, the aggrieved, we, the people, are left with no adequate remedy, no way to review it. You did the in-class exercise. We spent a great deal of time looking at Michigan versus Long decision from the Supreme Court of the United States. You saw that in those extremely rare instances, the Supreme Court of the United States lacks jurisdiction, can't review the decision. You may feel the decision is wrong, but you have no place for review. So all you can do is abide by the decision, right? That's my point there with that question. So with all of that said, think about this question for a moment, would you? Assume you agree that the statutes and rules of judicial ethics leave judges with sufficient leeway to interpret the Constitution in a partisan fashion without losing their jobs, without suffering discipline. Assuming you agree with that, bless you, is it right, is it wrong? Again, here to educate, not indoctrinate. But assuming you agree with that, then what other potential sources of judicial restraint might exist under the Florida Constitution? And this is just another way of me rephrasing that loaded question that I left unanswered from last week. And that, oh God, I just tripped over it. The living Constitution just went running by. The U.S. Constitution, living Constitution. Don't trip. Be careful. Sit, U.S. Constitution. Sit. Good Constitution. Somebody throw a Constitution bone, would you? Is the state, thank you for throwing the Constitution bone. Thank you. Most importantly, thanks for not throwing anything at me. I appreciate it. But the semester is young, right? There you go. All right. So, is the state constitution the same thing? Is the state constitution a living constitution? The answer, begging the question for this long, how about I provide an answer? The answer is this. Applying that concept of subsidiarity, each state gets to choose for itself. The state of Florida has chosen that there are canons of construction, canons, rules, canons of construction that apply to all of Florida's Article 5 courts, whether they be the trial courts, whether they be the county courts, whether they be the circuit courts, whether they be the district courts of appeal. Even when the Supreme Court of the state of Florida is deciding a case, case law says that always we must apply in Florida canons of construction. So one possible answer is that although the proper method of interpretation of the federal Constitution is within the discretion of the individual U.S. Supreme Court justice, that same discretion need not exist for state judges interpreting their state constitutions. It need not. And here in Florida, my research concludes, let's go over it and see if you agree. My research concludes that there is less discretion for Florida Article 5 judges because they are bound by what I'm referring to as the canons of construction. Let's look at those canons of construction, shall we? Let's put them all up on the big board. Now, I'm going to go over these in a rather quick fashion. One of the reasons I do that is because there's so many. The other reason I do that is because I don't find, you'll correct me if I'm wrong, I don't find any of the particular individual canons to be all that intellectually hard to grasp. Maybe they need a quick explanation, and that's what I will give them. The book I've written for you has far more detailed explanation. Within those detailed explanations are citations to case law precedent. You've all got a Westlaw or Lexis or see them, Bloomberg, Google Scholar, Fast Case. You've all got the internet, right? So you can pull up that case and get further instruction about it. But let me go over each of the canons of construction and put them up on a big board. First up on the big board, one of the canons of construction of Florida's Constitution, one of the rules all Article 5 courts are to follow, is to obey the clear and unambiguous language in the Constitution. Obey the clear and unambiguous language. Now, what if the language is neither clear nor unambiguous? Well, let's think about that. Then the rule wouldn't apply. I told you, this is not intellectually difficult to understand, right? You following me so far? If the language is clear and if the language is unambiguous, then you do what the state constitution says. Make sense? Yeah. So another way to phrase that. First, step one, begin with the actual language of the constitutional provision. You're very wise a moment ago mentioned the textualist approach, right? Some justices on SCOTUS, they may prefer a different approach. Here in the state of Florida, under Florida's Constitution, are Article 5 judges, which are our Florida Supreme Court, our district courts of appeal, our county courts, or circuit courts. Less discretion. Step one for them is to begin with the actual language of the constitutional provision. I've lamented so many times that you took Con Law 1, you took Federal Con Law before you took this class, and most of the time, you never even opened the U.S. Constitution. You had a big, thick book that didn't even bother to include the text of the U.S. Constitution. What we're talking about here is the opposite when it comes to subnational constitutional law, at least here in the state of Florida. Here, step one is to open the Constitution and look at the language. After step one, we analyze that language. When that language prescribes a manner of doing an act, the manner is exclusive, and the legislature may not enact a statute that would defeat the purpose of the state constitution's provision. We look at the text of our state constitution, and sometimes we see a statement of ideals or goals: freedom of religion, freedom of the press, freedom of speech, rights of the criminally accused. And sometimes that's where the Constitution stops. It gives us a concept, it gives us an ideal, it gives us a goal. Other times, especially in subnational constitutional law, especially in state constitutions, parts of the Constitution read with detail akin to a statute or an administrative code rule, spelling out exactly what needs to be done. For example, in Florida's Constitution, women who are pregnant women are not explicitly mentioned. Pigs that are pregnant, swine that are pregnant, are explicitly mentioned. And the rights of pregnant pigs are spelled out in great detail, spelling out the number of feet and inches for the pregnant pig's captivity, for its cage. The rights of pregnant pigs are a very important part of the Constitution of the state of Florida. Think I'm making it up? Go to the website, got a link to the Constitution, see it for yourself. If you wanted to create a Florida statute spelling out a different dimension for pregnant pigs confines, that would be unconstitutional under this canon of construction. So good. Are pregnant pigs here in Florida well protected?
No.
I swear it. Read the text of the Constitution. How often does a common law professor say that? Read the text of the Constitution. It's in there. It's in there. So, where the Constitution of the state of Florida expressly provides a manner of doing a thing, it impliedly forbids that thing from being done in a substantially different manner. The case I've got for you to look at was City of Jacksonville versus Continental Can. Okay. Yes. Oh, question. Yes. Was it about Jacksonville or Cans? Just kidding. What is your question?
About the previous slide,
With the pregnant pigs.
the pregnant pig, yes. If the legislature went to enact statutes that went above and beyond the Constitution's floor, can they do that?
Absolutely. The first canon of construction would not interfere with the legislature honoring all constitutional rights and attempting to provide greater rights. It would not. The caveat being that under that first canon of construction, if Florida's Constitution spells out exactly how to do a thing, stated somewhat differently, if the relevant text of Florida's Constitution read more akin to a statute or an administrative code rule in its detail, you've got to abide by those details. You can't enact a Florida statute contradicting those details. You can implement those details. You can abide by all those details and add additional details that don't contradict those details. And I talk here in theoretical terms. Let me see if I can make that more concrete. Let me see if I can make up an example. I've harkened on the pregnant pigs quite a bit. Let me keep running with that. Say that the Constitution spells out exactly what size pen they're supposed to be in, and you also want to pass additional rules. They don't contradict the pen size, but it also involves how they're transported, what kind of trucks, how they're fed, what kind of feed. That would be not a violation of our first canon of construction.
I guess what I'm asking is, let's say the pen size is 5 by 5.
You're sticking with the pregnant things, like it. Okay. Hypothetically, 5 by 5 pen.
According
Okay.
to Constitution.
Okay, I hear you.
Legislature, after listening to their constituents, now decide that pen size should be 10 by 10.
Ooh.
What's the course of action?
We
Do
look at the
reform
language.
Constitution?
Step one, open the Constitution. I know, a constitutional law professor shouldn't say such blasphemy. Step one, open the Constitution, look at the text, right? And analyze that text to see if it's clear and unambiguous.
It's clear enough.
If it is, then take its requirements and see if the legislation you're attempting to challenge contradicts those requirements. If not, then you're okay. Makes sense? I'm explaining it well. Sometimes I'm lucky explaining things well, other times maybe I don't. Stop me if I don't, because I want to. Okay. 3 takeaways from Continental Can. We talked about pregnant pigs instead of cans in Jacksonville. Sorry about that. But 3 takeaways from Continental Can. Read that on your own. I cut that excerpt down to just 1.25 pages. You can do it. You can read 1.25 pages. Takeaways. Number 1, if clear and unambiguous, no construction is allowed. We've seen that in federal con law, in Con Law 1, right? We saw where SCOTUS engaged in a construction of the Constitution. There I was in charge of filling Patrick James's bowl after he and his mom, my wife Bernadette, signed that document. I was supposed to bring him a bowl of chocolate ice cream, but I engaged in some construction and I brought him a bowl of steaming hot broccoli, right? No construction allowed, says the Florida Constitution, Canons of Construction of Florida's Constitution. No construction allowed if the language is clear and unambiguous. How do I know if the language is clear? How do I know if it's unambiguous? I turn to the definition of the word. I'm going to use the usual and obvious definition. Which one is the usual and obvious definition? I got a definition for usual and obvious. The definition of that is that it's the natural and popular one, right? On final exams, we're looking for depth of analysis. So here's some vocabulary, here's some language you can use to give me a deeper analysis. On the flip side, if you want to be a successful lawyer, you're also going to want to engage in some deep analysis from time to time. So here's how you do it. Third takeaway from Continental Canon. We depart from the clear and unambiguous language only if absolutely certain that it's not clear and absolutely certain that it's ambiguous. So again, in a way, these kind of tie the hands. They don't completely tie the hands, but perhaps more tied hands under the Florida Canons of Construction of Florida's Constitution than we would find under the U.S. Constitution, perhaps. That's what I suggest. That's my argument. So up on the big board, first canon of construction. We're getting close to our first break. We're taking a break soon. Second, to add to the big board, presume a law or action is constitutional. Presume it is constitutional. We all watch the news from time to time. Maybe you watch the real news, maybe you watch the fake news, but we all watch something from time to time. And it seems the only time something gets on the news is when it's been stricken as unconstitutional, right? And it would seem to the laywoman, the layman, the non-lawyer, that maybe just by yelling, that's not constitutional, that's enough to shoot something down. But one of the canons of construction of Florida's Constitution is a reflection of those times when we don't apply strict scrutiny. It's a reflection of those times where strict scrutiny does not apply. The result there is that the law or governmental action is presumed constitutional unless and until proven otherwise. When strict scrutiny does not apply, who bears the burden? The challenger. When strict scrutiny does not apply, who bears the burden to prove what? The challenger bears the burden to prove that the legislation or the action by the government actor is a violation of a constitutional term or a constitutional right. So we presume, unless strict scrutiny applies, that the legislation is constitutional. We presume, unless strict scrutiny applies, that the government actor's action is an action the actor was allowed to take under Florida's Constitution. With certain rare and narrow exceptions, such as a prior restraint upon free speech of a political nature, a duly enacted law is presumed to be constitutional, and Florida's Supreme Court recognizes that one asserting the unconstitutionality of an act has the burden of demonstrating clearly that the act is invalid. The takeaway: 1, a finding of unconstitutionality is disfavored. Don't be deceived by the news. Every time you hear, oh, they challenged the constitutionality of that and they won, you kind of get the feeling, oh, you just mumble, unconstitutional, and there goes the democratically enacted law. No. That finding is disfavored under the canons of construction of Florida's Constitution. There's 2 hands up. I think, who was first? Were you first?
Just a small question.
Yeah.
Forgive me for misunderstanding.
There's no small questions, just small answers.
So
I don't know. Is that funny? I don't know.
I like
I'm just going to keep telling jokes until I get a funny one. Yes, go ahead.
presumption of constitutionality, isn't that where laws that prevent Asian Americans from buying real estate come from? Like, isn't that why certain laws stay without getting uprooted is because people are like, no, it's probably fine. It's probably constitutional.
Yeah.
And then
Now
it's
you're talking about a phrase that was in Article 1 of Florida's Constitution until last year, until 2018.
That's
You're
the reason
talking
why-
about that phrase we talked about before, where due process of law applies to everyone except for aliens ineligible for citizenship, which under our canons of construction would be interpreted to mean Asian Americans. You're talking about that language that, thank God, got stricken from the Constitution finally on a second try last year. But that may not be the perfect example of the point you're trying to make. I think I hear your point. I think I hear it loud and clear. You're trying to say, do things stay on the books longer than they need to because of this canons of construction? And I don't think so. You are correct insofar as when we look at the national news, when the layman, the laywoman, the non-lawyer watches the nightly news, they hear repeatedly in the modern era about just a particular U.S. District Court judge whose territorial jurisdiction is just a particular part of the U.S., entering a nationwide injunction, stopping the federal government from doing things anywhere and everywhere. We hear that all the time in the modern era. I don't think this canon of construction either contradicts or not contradicts that. There's still the potential in state court to get an injunction from a territorial county, or I should say circuit court judge, that judge would apply on a statewide basis. That can still happen. Whether it could or whether it should, that's a matter of opinion. But to educate, not indoctrinate, that is a possibility, even under these canons of construction. I think that's where you're going.
Yeah, very happy.
All right, okay. And then I missed another hand that was up.
Could
Yes.
you go back to the burden of proof?
Oh, yeah, I can go back. I got buttons that go forward, back, and well, I'm just kidding. I understand what you're saying. You want me to talk about that some more?
Yeah, what did you say about the burden of proof again?
Yeah. Okay, here's what I'm trying to say. Assuming, I'm jumping ahead a little bit because this comes later in the lecture, the standard of review is not strict scrutiny. In any other standard of review, the person who's coming to court yelling, unconstitutional, 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 that's the person with the burden of proof. Assuming strict scrutiny doesn't apply, and somebody's yelling, unconstitutional, what is it that is their burden? What are they burdened to prove? They're burdened to prove that the law is unconstitutional. They've got to point to a constitutional right, a phrase in the Constitution, case law precedent interpreting the state's constitution that creates that right, and show the violation. The burden of proof is theirs. And the whole time, if the judge is following the canons of construction, then she or he is reluctant, is doubtful, or stated somewhat differently, is presuming the legislation or action is constitutional. So that's what I'm trying to say there. Does that explain it better? Oh, sorry about that. Yeah, but okay. Okay, all right, okay. So, a finding of unconstitutionality, therefore, is disfavored unless strict scrutiny applies. The judge, if the judge is doing the judge's role right, is attempting to avoid ruling that it's unconstitutional. Okay? All doubts are resolved in favor of what? Of favor of constitution. It must be clearly unconstitutional beyond a reasonable doubt, says the case law precedent in the state of Florida that talks about this particular canon of construction. So that puts a second canon of construction up on the big board. The next canon we'll discuss after our 10-minute break, because who wants to listen to me ramble on and on for more than an hour at a stretch, right? Time for a break, sound good? Yeah. We'll take 10 minutes, and then we're going to consider stare decisis. Okay, see you in 10.
Oh my god, you can make money.
Oh, I didn't know that. I can't sign this shit yet.
Okay.
Yeah, here, get your name on there. Why are we? I gotta put it in
Oh, yeah, it's not.
Join up.
I know, this is so much
I fell away on my own. It wasn't my parents. Okay. Oh, seriously? All right, that's cool. Yeah, I got one. It was a friend of mine before he became still. Yeah, I imagine. Like school, work,
pretty much. So the way that I would understand it, I don't know. Whether the judge decides to oh, so that's different from the rule that applies to the Okay, so then what is that for the voting? Okay, so that it's being court as like a court with all the judges.
Yeah.
And then there's something else. I put the basic.
It's 150.
20, definitely 20.
Difference.
20 plus what?
And I tend to do that.
Palmer, there's some other thing, right?
Wait, what do you mean?
Try to figure that state. Different choices that come from my perspective.
So whatever taught it to them first, but maybe. Yeah.
Yeah, so then that applies to all the Florida judges from the circuit court all the way to the end. Okay, so then what about the federal judges that are up for? They follow the
Judges, which I mean, the courts that were created before this constitution. So as you stand here today,
Yeah.
the circuit, so they have jurisdiction in Orange County. Jurisdiction. Over also the Middle District. That's a whole separate system.
It's called, yeah, they want to for that.
Yeah, like.
Fancy and force you to go.
Yeah.
So the next time.
Okay. Wait, all right.
I was just like, whoa, that's big. It took me like
I know, me too. I saw, I'm nosy. So I was like, ooh, like, how could she guys? I was like, so. I didn't mind my mouth. I was like, what did you say? Like, some of the words like that. I was like,
Yeah.
No, that's not really good.
I'm young. We've been busy, man. I was in court all day today. Nice. They want me on the record probably next week, so I'm like, keeping this case learning.
This is one that I didn't.
As long as you.
Starting to learn people. What do I have to model? They buy it.
Oh, so you're in the.
Yeah, and pretty much any kind of.
Is it the one that? Yeah, they was right. I'm telling like the whole story. I told the story, but that's what I did.
You go up there and just read it back.
Oh, no, I haven't gone back in there, but I really, I was like, incorporated the story.
At least you're celebrating.
I don't know that.
I think he's gonna vote in first. I think he is.
I'm regretting my.
Also, he does that. We'll be back in business. I thought that was it. I was just looking out. I got a lot of stuff. But anyways, I love shit at home. I don't think I don't think I've ever worn a collar shirt. I almost wear one today. Because I was like, if I'm looking at the leaves, I'm looking at the collar shirt. But I looked at it. Because you're artist. That's fine.
I love it. But don't make her choke on the chair. You're gonna pull that out.
Yeah, really.
Yeah, I got those two. Thanks for the two.
I just figured like somebody was down. I'm like, you're man, you before like company there, you buy every brand of shoes. You know.
I know, but. Well, you want to run a 5K with me?
Yeah, I'm really glad you would if I went.
Monday the 16th.
I was thinking about that too.
I hope so.
Cocktail party.
Right. On this microphone. I think I turned on the microphone. Okay, welcome back. Everybody get a long enough break? Anybody need a longer break? I don't know, maybe a 4 or 5 hour break? I just kidding. Anyway,
I was like, oh,
welcome back. Something I've been mentioning for quite some time. So lead council. You know, we had some lead council last week, which I neglected to meet and introduce, and now we've got this week's lead council. So today's lead council introductions will be approximately twice as long as usual. But bear with me because I think it's a valuable part of the class. And why do I do it? Well, primarily it's selfish. That's the reason I do most things that I do. As the years go on and I see my former FSU law student classmates doing amazing things, seen them on television, saw them the other day literally interviewing the United States Supreme Court Justice, just to sit next to her in class. That's going to happen. Not only are you going to be a huge success, but to paraphrase that infamous movie, look to your left, look to your right, they're going to be a success too. Yeah, so it'd be nice if I could get to know you. I really would like to do that. But I respectfully suggest it would be good for you if you got to know one another. So bear with me here as I perhaps introduce or get introduced to someone you already know, but probably someone you don't know well enough, right? So bear with me, get some introductions here. Got to start with last week's lead council. I think we had 2, maybe 3 on the list. At least 1, maybe 2 other people were smart enough to add their names to the list after the fact. Now that's good lawyering. That's good lawyering. That's how you work the system, right? I respect that. So let's meet these 4 lead councils, some of which actually were lead councils, some of which are just getting credit for it. Good for them. Good for them. The first name I see on the list, you see the list up there. If this website looks strange or foreign or haven't seen it before, then you probably should check it out. But anyway. Okay, number 1, Scott Green. Yes, Scott Green, nice to meet you, sir. Yeah, good to meet you. What is your alma mater, Mr. Green?
Valdosta State.
All right. Who else? Valdosta State alma mater. All right. You represent the entire school. Pressure's on. And what was your major at Valdosta State?
Criminal justice.
Oh, wow. Okay.
Jeez.
Yeah. I don't mean to sound like I'm for injustice,
No,
but
that was
the
talking
topic I have the least interest in would be the criminal law. Yeah, but yet that seems to be your focus. So I hope I don't let you down in this class. I hope I cover it well. Yeah. Those who know me well know I can buy a little help from my friends. I bring in prosecutors and defense attorneys to help cover the criminal law. All right. But the question I really need to know, and I might ask this question to more than one of you, why law school?
Because I was undergrad for criminal justice. I kind of wanted to do it.
Okay.
So, like,
People, I don't know why.
yeah. So, I think it's a good time.
Okay.
Maybe not all the time.
All right. Mr. Green, thank you for having volunteered last week. Job well done. Also last week, number 2 here on the sign-in sheet, Rebecca Farinash. Did I pronounce that correctly? Oh, I was hoping I did. Ms. Farinash, good to see you again. What is your alma mater?
University of Tennessee at Chattanooga.
Oh, UT Chattanooga. Anyone else? Anyone else? Again, pressure's on. You are representing UT Chattanooga. I know you'll do well. What was your major?
Criminal justice.
Oh, okay. You and Mr. Green, both criminal justice. All right. But the question I really want to know, why law school?
My dad's an attorney, and I really look up to him, and he's my hero.
I like that. Yeah. All right. Well, welcome. Thanks for serving well last week. Number 3 from last week's list. We're halfway done. For those of you who hate this part of class, Alexander Lemieux. Oh, Mr. Lemieux. Yeah. Thanks for volunteering. I appreciate it. Yeah. Mr. Lemieux, what is your alma mater? Oh, University of Baltimore. Who else? University of Baltimore.
I was close.
Close? You're close to Baltimore.
Yeah, you have to see.
Hey, all right. Okay, so Baltimore's well represented.
Yeah.
I like that. All right. And what was your major? Wow. Okay. They say those who don't learn the lessons of history are doomed to repeat them. Boy, are there a lot of lessons from history we better not repeat from that particular period, right? Yeah. All right, I like that. But the question I really want to know, why law school? All right, and here you are. All right. Well, Mr. Lemieux, thank you for volunteering. Yeah, no, thanks for coming. All right. And but fourth and not least, because the last shall be first, Julie Herring. All right, Miss Herring. It says here USF. Go Bulls. Go Bulls. Who else represents USF? USF. USF. Oh, I like the way you like the way. I gotta learn that. That's what I say. Go Bulls. Okay, all right. Okay, all right. I'm learning. All right, USF. All right, fine alma mater, well represented in this room. And what was your major?
My undergrad was history, and my master's was library information science.
Oh, so history, like Mr. Lemieux. All right, and adding library information science.
Yes.
Because after all, when's a lawyer ever need to do any research, right? No, that's probably a good background for law school.
Yeah, it was. Actually, I wanted to go to law school because I wanted.
How'd you know I was going to ask that question? Yeah, why law school?
Because I wanted to become a law librarian.
Oh, wow.
But now it's been so interesting. I think I want to practice.
Why? World's your oyster. Yeah. All right. Well, awesome. And those are our 4 lead counsel from last class. I think they all did a great job. Let's give them a round of applause for job well done. All right. Thank you, everyone. Thank you. And now for this week's lead counsel, the few, the proud, those who've been voluntold. Yes. Will I treat them with the same brutality as I did last week? Yeah, probably. Okay. First on the list, Izzy. Thank you. I'm so sorry. I really wanted to get it right. Help me. Affiliate.
Close enough, a free A.
Tell me again.
A free A,
Affiliate.
80% there.
No, I want to be 100% there.
A free A.
Affiliate. You don't know how many times in my life I've been called McKinley or McGinley, but some folk are kind enough to stop and learn McGinley. Most of them just stick with hey you. But I want to learn. I want to learn. So please tell me.
A free A.
Affiliate.
Almost there.
Almost.
I want to be
You're
there.
putting the emphasis in the
Yeah.
wrong.
It's an
Okay. So
Yeah, free A.
for 3 syllables.
A free A.
Yeah.
A free A. A free A.
Oh my God. A free A.
All right. Every dog has his day. This is a free A. What is your alma mater?
Stanford University.
All right. Anyone else?
No, it's
Okay. And what was your major?
accounting and business.
Oh, wow. I'm a business major. Yes. I'm a business major. That's why I went to law school. I wanted to make money. Yes, but the difference between why I went to law school and why I'm still here, it's a big difference. I went to law school because I wanted to make money. The reason I continue to practice law is because I want to make big money. See, big difference. Big difference. So, but I gotta ask you, why law school?
I wanted to be a political legal analyst.
And you will. Yeah.
So,
And I'm glad I could be a small part of your journey to get there. Thank you. Yeah. Our second lead counsel, Chelsea Walker.
Me.
Oh, hi. Ms. Walker, what's your alma mater?
I went to agricultural technical state university.
All right. Who else? Who else? North Carolina Agricultural and Technical University.
Technical state university.
Sorry. But thank you, because I want to know. Yeah. And what was your major?
I have my BS in economics law.
Economics. So another business major.
Yeah.
Yeah. So do you mind if I happen to focus on some of the business aspects of law? I don't mind either. All right. But I gotta know, why law school?
You know, it was one of my supportive
I like that. Well, you're here. Yeah. You did. You did. I'm not here. All right. Well, thank you, and thank you for volunteering. A third out of 4, so we're almost there. Elena Morgan. Elena Morgan. Hi, Miss Morgan. Yeah. What is your alma mater?
UCF.
UCF. That's where I got my undergraduate business degree. I had 2. I mean, UCF Knight. Where's my fellow Knights? Go Knights. Yeah. Now we know how to win football games, do we not? Yeah. Go Knights. What was your major at UCF? Oh, wow. Okay. So with that major, you kind of knew you were heading to law school.
Yes.
Did you find it's a good major for law school?
It helped them, like I took property and evidence, things like introduction to contracts, so kind of.
Is that fair that she took these things before she got here?
It's a crash course.
Yeah. All right. But I got to know, why law school?
I thought I was wanting to be a criminal defense.
Okay. But the way you answer the question, I'm thinking maybe you're not leaning toward the same focus.
Not since being in law school, I think that changed course a little bit.
Okay. Well, part of the beauty of getting an education is finding out what we're interested in, what we're not interested in, what we're good at, what we're not good at, right? Yeah, there's nothing wrong with that. Yeah, and thanks for volunteering. And we've got, oh, I can see right here, can't I? Yeah, we've got one more lead counsel, Samantha Lambert. Miss Lambert, yeah,
I'm here.
welcome. Yes, front row.
Yep,
All right, can't hide.
right next to a little doggy.
There you go, our living constitution. Sit. Your alma mater is SJSU.
San Jose State University.
Oh, wow.
In the
Who
Bay
else
Area.
represents San Jose State? You're doing all the representing.
I went,
Oh, what?
Oh,
You did.
did
You
you?
went there.
I did a postmaster's certificate there.
What's the school mascot?
Oh, a Spartan.
Go
Yeah.
Spartans.
Yeah, Spartan.
All right. Yeah. And what was your major there?
Justice studies, So like a little bit more of a liberal take on criminal justice.
Oh, wow.
Yeah.
Okay. Yeah. So again, like you probably both had law school in mind, even as an undergrad.
Yeah.
Yeah.
And
So I
I'm
gotta
here-
know.
Yeah.
Why law school?
I feel like it's where I've always been meant to be. I've just always been drawn to the law. So
I like that answer.
thank you.
All right, so those are our lead counsel. I know they're going to serve us well. Since we know they're going to serve us well, let's go ahead and give them a round of applause. All right, let's switch this back to our slide presentation. Let's see here. Present. All right, when I last left, before the break, I was putting the canons of construction up on the big board, and I asked you to consider stare decisis. Now, this is not your first class in constitutional law. You've encountered the concept of stare decisis before, haven't you? Raise your hand if you've encountered the concept. Yeah, so you know it very well. You've encountered stare decisis, and you know exactly what we're talking about. What we're talking about there is an artist who, oh wait, oh that's Starry Night. Hey, there's Starry Night too. Yeah, I always get those confused. Starry Night, stare decisis. Yeah, but technically they are different. So let's look specifically at stare decisis. In Florida, as elsewhere, stare decisis refers to the acknowledgement of precedent and the following of that precedent when the issues underlying that precedent arise again in later litigation. So what we're talking about there are two different types of stare decisis. You notice I boiled it down. I gave you a slightly, still a cursory look, but slightly deeper analysis in the text there. I talked about rule stare decisis, and I talked about result stare decisis, two different kinds. The rule stare decisis involves the Florida Supreme Court's choice of the applicable legal standard or test. On the other hand, result stare decisis is the result reached by applying that legal standard to the particular facts of the particular case. Perhaps a fine line without further explanation. So let's try to explain it a little bit better. Let's look first at rule stare decisis. Rule stare decisis. Here, a particular rule or statute has to apply in a particular case because of rule stare decisis. Compare that instead to result stare decisis. Do you see my power? Yeah. You see my power? Yeah. Result stare decisis. I can do something to keep you awake when we talk about a topic this dull. Result stare decisis results in requiring the outcome of today's case being the same outcome as in the prior case. So we're talking about what the statute means, when it applies, where it applies. We're talking about rule stare decisis. When we're doing research to find almost identical facts in some case law precedent, we're talking about result stare decisis, right? A statute seems vague, it seems ambiguous. We look at various examples of when the statute applies and how it applies. We're talking about rule stare decisis. Our facts involve an elderly woman who was held or removed from her home against her will. Perhaps she was Baker acted. We're looking for another case where someone was Baker acted, where it was against their will. We're talking about result stare decisis. I've run out of excuses for slapping the video. And hopefully in so doing, I've illustrated the hair of a difference between the two types of stare decisis. And that brings us to Hague versus State, or is it Hag versus State? Is there a Hague or a Hag in the room? You can tell us whether I should pronounce it Hag or Hague. Yes, Mr. Hague or Mr. Hag.
Well, it's not my name. It's my fraternity brother from undergrad.
Your fraternity from brother, it's
It was
Haas?
Haas.
It's neither Hague nor Hag?
It was Haas was his name, so I'm saying Hog because it's close enough.
Well, no, pick one. Is it Haas? Is it Hag? Is it Hague?
Hog. It's
Hog.
Hog because it's spelled the same way as my buddy's name, which is Haas.
I'm just not nailing the names today. Okay, all right. Thank you for putting up with my name. So, H versus State. Let's talk about H versus State. What was going on there? This was in 3850. What? A Florida rule of criminal procedure, 3.850. This is a post-conviction motion to vacate, set aside, or correct the statement. This is Florida's rule implementation of a writ of habeas corpus. Have we heard of the writ of habeas corpus? Who's heard of the writ of habeas corpus? Who themselves has needed a writ of habeas corpus? That you wouldn't be in this room at the moment if you were still in need of the writ of habeas corpus, right? Because what is a writ of habeas corpus? Where's my lead counsel? I got to call on one of my lead counsel to tell me what a writ of habeas corpus is. And please remember that universal sign of whether or not you want to be called on. If you don't want to be called on, you look somewhere other than at me, right? Right? So you might look down, right? I don't know, that Starry Night, Van Gogh, you might be looking up at the stars, okay? But now if you're looking at me, don't be blaming anyone but you if I call on you, okay? Yeah, so where's my lead counsel? Wow, everyone took my phone. I don't see anybody looking at me. Mr. Lemieux actually left the room. Just kidding, Mr. Lemieux. No, but you are looking at me, sir. Okay, all right, then what? Pray tell. Is that a real word? What is a writ of habeas corpus?
So a person's under arrest and they were brought before a judge or a court, they have to file this. So like in case of state court,
I like that. Did everyone catch that definition?
Yes.
Other uses of writ of habeas corpus outside of the criminal law. What about custody? What about the family law? What about quasi-criminal action? What about Baker Act, Marshman Act? What about any instance where someone's freedom is curtailed? They're literally or imprisoned or outside of their freedom of custody. This is where you might find a use for writ of habeas corpus. But here in Hag versus State, tells us a basic guarantee of Florida law is that right to relief through the writ of habeas corpus, which must be grantable of right freely and without cost. We see over here that the person wanting habeas corpus was in custody, and was trying to file a writ of habeas corpus. We talked about, in the case, the federal mailbox rule in the federal system. Once that writ of habeas corpus left the prisoner's possession and was given to the guard or the warden or someone who was free and could then mail or file or process that writ of habeas corpus under the federal system, under the mailbox rule, that would be the date of filing. But as of the time in H versus State, when it was decided, that wasn't the rule in Florida. A delay by the guard, by the warden, by something outside the prisoner's control could mean that even though the prisoner gave up control and filed or tried to file that writ by giving up control in a timely manner, ultimately it wasn't filed timely, and it was the prisoner who paid the price. That was the stare decisis. That was the rule before H versus State. But H versus State overrules the precedent. In so doing, it gives us an example of when and where stare decisis applies. More importantly, it gives us an example of when courts won't apply stare decisis and instead will overrule prior precedent. Take a look at it. We recognize, the opinion says, that our opinion today recedes from and overrules earlier precedent in this jurisdiction. It then cites 1, 2, 3, 4 cases, quote, contains results or analyses inconsistent with our views and accordingly are disapproved to the extent that they conflict with this opinion. We're also receding from 1, 2, 3 to the extent that they conflict with the views expressed above. Now, the explanation. How did they get around stare decisis? While the doctrine of stare decisis normally would require greater deference to this prior precedent, it sounds like an army of precedent, doesn't it? We find that the demands of justice and the principles of constitutional law recited above require an alteration in the precedent, as is self-evident. It's a great way a court can say something when there isn't any precedent, right? as is self-evident, even the common law must bend before the dictates of the Florida Constitution. I like that. Okay. Continue now in another paragraph. Moreover, as we've said before, stare decisis is not an ironclad and unwavering rule that the present must always bend to the voice of the past. However outmoded or meaningless that voice may have become. Ooh, we wax poetic here, do we not? It is a rule that precedent must be followed, except where departure is necessary to vindicate other principles of law or to remedy continued injustice. Wax is poetic, but does it give us actionable language? Does it give us a firm rule of law? Does it give us confidence to know when stare decisis will be ignored, set aside, not applied? And I ask that and to build some questions to consider, such as question 1, what are Florida's exceptions to stare decisis as identified in this case? Hague versus state, Hague versus state, H versus state. Did I pick a pronunciation?
You bounced.
I bounced. Bounce versus state. In bounce versus state, what are the exceptions to stare decisis? Which of my lead counsel can summarize this in a concrete way, in an actionable way, and things that I can apply even-handedly, maybe perhaps mechanically? Yes, tell me, Mr. Lemieux.
I assume you don't well know, right? Basically, some people say that it's habeas corpus relief, equal protection, equal access to the courts, or the fundamental rights set forth in the Constitution, Article 1. That's what he said.
So you find this rule in the opinion.
Yeah.
And I can't disagree that you're reading for me the opinion, but if I could ask you, in your opinion, does the case provide us with a concrete, actionable, mechanical, die-hard, clear rule of law?
No, it's wrong. It's just a fundamental right.
Yeah. And that would be my critique also. Who would disagree? Who would say, yeah, I can look at bounce versus state here, and I can always tell whether stare decisis will carry the day. Yes.
It's not an ironclad rule.
No, I agree. This case is not presenting us with an ironclad rule.
We're a black letter law
Yeah.
result, but I think it seems pretty obvious though that if stare decisis is going to be ignored, it would only be ignored if the result would be unfair.
Okay.
Obviously patently unfair, and in this case it would have been for the technicality of a few days.
Okay. Did everyone follow that? Because I like that summary. Yeah. So maybe we don't have a mechanical, an ironclad, is what you said, the boilerplate, a firm rule of law, one of a mathematical precision, but we do appear to have a rule of equity. Is that what you might say?
Yeah.
We have a rule of equity. And here the equities seem to have carried the day, did they not? The prisoner, through no fault of his own, lost control of the document which necessarily one in need of a habeas corpus petition would lose control because that individual would be imprisoned, would be lacking freedom, would be in need of habeas corpus. So, since the blame was not his, and the federal system had a mailbox rule, perhaps since the federal system had a mailbox rule, even though it wasn't the state rule at the time, it was not created whole cloth. It was not of great surprise. It was not an unknown concept. All these things weighed toward the equities of the situation. And it seems that equity can prevail over Florida's stare decisis. What do you think? Like that, somebody? I like it too. Well done. All right, so let's put considered stare decisis up on the big board. Big board's got a long way to go. Also, determine the intent of the framers or the voters. This is a canon of construction. This is a rule of construction of Florida's Constitution. Is this a rule that must be followed for the U.S. Constitution? No, it's not. There, the judges, some of the judges might might espouse a belief in determining the intent of the framers, of the authors. You remember that big bowl of steaming broccoli I brought to my son? When I brought that big bowl of steaming broccoli, I was more concerned for his health and welfare than I was for the intent of him and his mother who wrote and signed that document, right? So from the perspective of a living document, and I've been rude to our living Constitution. I've made our living Constitution stand this entire time. Let's give our living Constitution a chair, shall we? All right, you can sit right here, living Constitution. There you go. All right. So our living Constitution will be sitting right there. So when we talk about determining the intent of the framers or the voters, we see less freedom, if you will, of the judges and more judicial restraint. Perhaps something to consider. Again, not here to indoctrinate, here to educate. But what do we mean by determining the intent of the framers and the voters? For the U.S. Supreme Court, that's a political question, but not so when it comes to Florida's courts interpreting Florida's Constitution. Because here, unlike the living Constitution, we do have a rule that you've got to at least consider and determine the intent of the framers and the voters. Binding case law precedent of Florida Supreme Court tells us that in construing the provisions of the Florida Constitution, the first step is to ascertain and effectuate the intent of the framers and the people. Could it be that there's a difference in subnational constitution and determining the intent of the voters or the framers? Could it be that there's a difference because of the way the Constitution comes about? Of course, it's at least theoretically possible that all day, every day, we could pass a new amendment to the U.S. Constitution. But in practical terms, is that what's going on? Do we see rapid developments? Do we see multiple amendments? Have you seen a single amendment to the U.S. Constitution in your lifetime? Compare that to subnational constitutions. If you're a voter here in Florida, have you ever even once been to the polls where there wasn't a new constitutional amendment being proposed and they're asking you to vote on it? It seems Florida Constitution, like most state constitutions, are quite frequently amended. So what we have there are the people of the state looking and voting. What did the words mean to those voters? What did they vote yes or no on? We determine the intent of them voting yes. We determine the intent of them voting no, and we give effect to that intent. That's what this particular canon of construction is attempting to do. Step one, give Florida's Constitution's words the meaning suggested by the circumstances leading to the adoption of the constitutional provision the court is interpreting. Step two, courts may turn to sources such as documents of the Florida Constitutional Revision Commission and the Florida Legislature. Step three, prove that amendment. Later in this course, we will talk about exactly how you amend Florida's Constitution. We will see in greater detail the operation of the Florida Constitutional Revision Commission, the legislature, and ultimately voter initiative and how these ballots come to be. Some of them leave a paper trail. For example, when the Florida legislature meets in its committees, those committees have memorandum. You can look those up. You can see what they were thinking when they were drafting the various language that later became a proposal that later was voted on by the voters. Likewise, the Constitutional Revision Commission. When that happens, once every 20 years, happened just last year, it's a newsworthy event. You can see newspaper stories talking about or at least surmising what the Revision Commission might have been thinking. And that gives us some insight into the intent of the voters or the framers of that particular language of Florida's Constitution. And what I tried to do in these three cases, which I provided for you, I edited them down. The point of these was to talk about the procedure. The sort of these was to look at how each of these court decisions goes about implementing this canon of construction of determining the intent of the voters or the framers. What I believe you'll see as you compare these cases in this particular order that I've got them on the board is first a shallow or less deep analysis or dive into the intent of the framers or the voters. And then finally, in the third case, the deepest dive, the deepest analysis into the intent of the framers or the voters. So let's take a look at these cases one by one. Let's take a look at Department of Revenue versus Leon County. And as our lead counsel would surely point out to us if I dared to call on any of them, this case asks, can the Florida legislature pass a law keeping 6% of the Constitution's gas tax? Get to the canon of construction and trying to get to how the court determined the intent of the framers and the voters. So I'm going to boil down and, in a sense, blow past some of the facts of the case. Bear with me while I get them out there. There was an 1885 Florida Constitution. Later in 1968, it's our current Constitution. That's the last time, 1968, we tore up, figuratively speaking, an old Constitution and enacted a new Constitution. And each time there was a tax imposed on the sale of motor fuel, 2% per gallon. They were taxing motor fuel in 1885? Hey, we might have questioned the facts of this case, right? All right. Now, what we've got here is a statute implementing Florida's Constitution. Sometimes, as I mentioned, and as you've observed, because in this class we open the text of the Constitution, sometimes the Constitution talks in broad terms. It states a lofty ideal without much detail. Other times, the Constitution itself provides a plethora of detail. It reads more akin to a statute or administrative code rule. When it doesn't provide in the text of Florida's Constitution all those details, all that minutia, often we need what we'll refer to as implementing legislation to fill in the how and the why and the wherefore. In our next lecture, we're going to look at, for example, the Florida Civil Rights Act. And we're going to see the implementing legislation for actually enforcing our civil rights that we have as Floridians. So that'll be one example of implementing legislation. And we have one here, the implementing legislation. But that implementing legislation is being challenged as unconstitutional. The parties agree that the 1885 Constitution prohibited the legislature from keeping the 6%. The issue is whether the 1968 Constitution authorizes the deduction. So what did we turn to in order to answer the question? You see here, the court says the 1968 Constitution as amended cannot be read as abolishing the prohibition expressed in the 1885 Constitution and incorporated into the more recent Constitution. So what the court did to interpret the intent of the voters is to look no further than the text of the Constitution. Specifically, we compared the prior text of the 1885 version of Florida's Constitution to the current text of Florida's current 1968 Constitution. That was as deep as we got to determine the intent of the voters. But now let's look at another case. I'm going to cover 3 cases in rapid succession. Keep up with me now. Let's turn our focus from Department of Revenue to Leon County. Let's instead look at Gallant versus Stevens. And has that gotten old yet? I'm still enjoying it, the whole light up thing. Has that gotten old?
No.
Okay, good. Because I don't have a lot of tricks up my sleeve, and that's just one of them. So, all right, okay. So let's look at Gallant versus Stevens. What's that, lead counsel? Yes, that is a fair summary. It's asking, can the Florida legislature authorize counties to create a taxing district without voter approval, covering and benefiting the unincorporated area of the county? That's the merits of the case, but I'm trying to get to the question of how do we apply this canon of construction, determine the intent of the voters or framers, to answer the merits of the case? So bear with me as I try to get past the facts so we can look at, if you will, the procedure. Here, what did we do to determine the intent of the voters? Did we look at the plain language of the Constitution? Yes, we did. You remember from our prior canons of construction, that was an earlier canon. You've got your canons in order. So you've got to do that first. You've got to look at the plain language. Remember why we're looking at the plain language? To see if it's clear and unambiguous, right? But here they found an ambiguity. They didn't find any ambiguity in Department of Revenue versus Leon County. They started with the plain text. They found it to be clear and unambiguous. So that was the answer as to the intent of the framers and the voters. If the language is clear and unambiguous, then the language is the intent of the framers or the voters when it comes to state constitutional law, when it comes to the canons of construction of Florida's Constitution. But in a slightly deeper dive, this Gallant versus Stevens opinion finds that the language was not clear, that it was ambiguous. So where else can I turn to determine the intent of the framers and the voters? Yes.
The court looked at the circumstances leading to the adoption of the provisions.
I like that.
And
Okay.
they
So
referred to
cool.
minutes and notes of the commission, report to the legislature.
Right, and you're going fast. Let me slow you down a little bit. So we're looking at the circumstances by which we looked at notes, right, or minutes of what?
Of the commission,
Of the commission.
Constitution revision.
Yeah, remember we talked about that CRC a minute ago, the Constitutional Revision Commission. What else?
And the second one was they looked at the court looked at reports of the legislature.
Legislative reports. Remember we talked a minute ago when the Florida legislature is creating laws, they're creating a legislative history insofar as committees are meeting, testimonies being taken, senators and representatives are voicing opinions, questions are being asked, documents are being reviewed, people are being heard, and notes are being taken of what happens, and a record is being created. We can look at that to determine. Anything else you want to add from your case? Anything else?
Oh,
That's as deep as they went.
I think so.
But that's deeper than they went in Department of Revenue versus Leon County. Why, under our canons of construction, were we permitted to go deeper in Gallant versus Stevens versus the depth we went in Department of Revenue? What about Gallant versus Stevens allowed us to turn to the circumstances, allowed us to turn to notes and minutes of the Constitutional Revision Commission, allowed us to turn to legislative history and legislative reports? Yes.
Ambiguity in the plain language.
Yes, ambiguity in the plain language. You're going to say that too, weren't you?
Yes, sir.
So your hands are up. All right. Who else wants to put their hand up and also be correct? There you go. All right. With that said, let's turn our focus now to our last case, Graham versus Herodopoulos. Here, the substantive question we're addressing, did the legislature set state college tuition, or does a constitutionally created board of governors set the tuition? Now, let's not focus too much on the particular merits of this 2013 case, because there have been amendments to Florida's Constitution subsequent to it that might alter the substantive answer that we find here. Again, I'm looking at this case because I want to see how the court applied our canon of construction, our canon being to turn to the intent of the voters or the framers. And how did they do that? What did they look at? You want to hit it again? You hit it out of the park last time, but let me give someone else a chance. You two will hit this out of the park, won't you?
Oh, yeah.
Yeah. All right. They started with the plain text of the Constitution. All right. And remember, that's the starting point. They went beyond it. What entitled them to do so? A finding of ambiguity in that plain language. You're batting 1,000. Keep going. So what then did they look at? Again, they turned to the circumstances. What gave them insight into the circumstances? What told them what they were looking for? Yes. The ballot summary. I add something else to the list beyond what was seen in the prior case. Oh, a slide to there it is. The ballot summary. What is a Constitution? Makes its way to the voters. The voters don't see on their ballot the full text of that proposed amendment. Instead, what the voters see is an approved ballot summary, the language of which can be challenged in court. So it has to be able to survive a challenge. The ballot summary. That's what the voters were staring at when they grabbed that magic marker and bubbled in yes or no, when they poked the Chad through Florida's ballot, hopefully not leaving a hanging Chad. That's what they were looking at. So that is more indicia of the intent of the framers of the voters. That shows a deeper analysis. Notes and questions to consider. What else is fair game? What else can we look at? We know we can look at the ballot summary, right? We can look at the legislative committee's notes, if there are any, the testimony taken, the legislative record. We could look at contemporaneous newspaper articles. They would give us a sense of what the language meant to the voters when they voted on it. We could look at legislative memorandum. Perhaps there was litigation about the ballot summary. We could look at not only the court opinion, but the briefs that were filed that led to that court opinion. All of this is insight. And it's objective insight. It's the kind of thing where you can offer evidence. It's closer to what I was looking for in stare decisis, a more mathematical, a more mechanical, a more firm, a less equitable, a more mechanical, a more objective, if you will, means of determining what the Constitution says and how it should apply. Slowly but surely, we see our canons of construction, if properly applied, are leading to judicial restraint. We began our lecture today with those surveys, right or wrong, correct or incorrect, about how so many of our fellow Americans see the Supreme Court of the United States as a partisan institution, as interpreting the Constitution the way they see fit, as being what I was to my son Patrick when I carried that bowl of steaming hot broccoli to him for dinner. Perhaps canons of construction, if properly implemented, separate a constitution from being an amorphous living creature that means whatever it is that the superhumans on the Supreme Court feel it is. And instead, something that we can determine what it is. Imagine, if you will, a constitution where you and I didn't have to spend years litigating to find out what our rights were. Imagine a set of rules we could apply and know what our rights are without spending years litigating. Perhaps there are advantages to canons of construction. Perhaps there are disadvantages. I've got a few more canons of construction to go over with you next week. But for me, it won't be next week. It'll be 2 weeks from now. Next week, you will be meeting one of my guest lecturers, my very good friend, Fred Trable. Fred is a criminal law former prosecutor, also currently a criminal defense attorney here in the state of Florida, former law partner to one of my personal heroes who I've never met. They say never meet your heroes. But one of Jose Baez. Anyone familiar with the name Jose Baez? Yes, Mr. Baez quite famously saved a life, did he not? We unfortunately live in an era where the death penalty is still a reality. The government can take away our lives, but at least in one instance, Jose Baez saved a life from the death penalty. Anyone who does that is a hero of mine. And a former law partner of Fred's. Fred's going to cover with you criminal law. You've got a question. Yes.
So you said we'll see you in 2 weeks.
You'll see me in 2 weeks. You'll see Fred in 1 week.
So will we see you with our papers in 2 weeks? Because that's the due date.
I am going to get back to you with the name of the faculty assistant who's going to collect those papers from you. Because I want blind anonymous grading. So I don't want anybody handing me a paper. Because that's, even if I have my eyes closed, it's neither blind nor anonymous. So I got to have that. But for next week, Fred's chapter is beginning on page 555. I know that you're always well prepared. I know that you always read before class, but you'll want to be particularly well prepared, and you'll want to definitely have read before Fred gets here. Former Fulbright scholar, former licensed teacher, former football coach, and a guy that doesn't appreciate if the person he randomly calls upon is not well prepared that day. So let's read chapter 15 and let's be ready to answer Fred's questions next week. I then will be back in 2 weeks to finish our canons of construction and then move on to the next chapter. But until then, you're going to be in my thoughts and prayers. I hope God blesses every one of you just the way he has showered blessings upon me that I don't deserve. Let's hope you get all that and even more. And until then, study well, and I'll see you next week. Thank you. Thank you. Yeah. I'll do that.
Okay. I'm late. So I want to make sure that I've got
The attendance sheet. Yes, I need the attendance sheet. Yes.
Good night.
Yeah, good night. See you next week. All done.
I thought of a practical joke that you can play on the class if you want to. Announce the guest lecturer, show up as yourself.